The number one threat to your assets during your lifetime for most people typically is long-term care costs. I mentioned earlier that Medicaid is the federal program, federal and state government benefits program that covers long-term care costs. As many people understand, Medicaid is what's called an impoverishment program. That's true, and it's not true. I'm going to give you a quick medical or Medicaid primer on some rules to give you context. Medicaid allows for a single person that they can have only $2,000 in countable assets. That pretty much is impoverishment. A single person, however, can have a car. Okay. They can also own their home, and the equity in their home can be $1,071,000. So that's not quite impoverishment. They can have $1 million plus house and qualify for the Medicaid program. So when it comes to a single person, there is a lot that an elder law attorney can do to protect that house so that it doesn't end up going to the state. We can help qualify the person for Medicaid, and through Medicaid asset preservation strategies, we can protect that house from the state's lien. So there are things that can be done. But if this person we're talking about that needs long-term care does not have a good, effective, durable power of attorney for finances, we might not be able to implement those Medicaid strategies that would protect the house. That's one of the reasons that you want to make sure that your estate planning documents are prepared by an attorney who has expertise in Medicaid. And typically that will be an elder law attorney, but not all elder law attorneys have that expertise. Ask the question. Ask your attorney, do you have Medicaid expertise? And if they don't, perhaps you want to find a lawyer who does. Let's talk about a couple. A couple in Medicaid is not an impoverishment program. The basic standard for a couple to qualify for Medicaid is in Washington State as of January of 2024, is that a couple can have between $70,000 and $156,000 in countable assets. Plus, they can have a car and all their personal possessions. Plus, they can have a house of unlimited value. It's not limited by the $1 million equity limit a single person has. So with a couple, they can have, a significant amount of assets. And beyond that, let's say this couple has $200,000 more than what's allowed in countable, $300,000 more than what's allowed in countable assets. Can we do a plan, a Medicaid asset preservation strategy for this couple to keep all their assets? The answer is yes, we can. Medicaid allows something called a Medicaid compliant annuity. And what that is that allows us to take the excess assets, put them in the name of the well spouse, that's the person who doesn't need care, turn those excess assets into non-countable by purchasing an annuity. And that allows us to qualify the ill spouse for Medicaid, and yet the well spouse gets to keep all of their assets. And beyond that, by transferring the name of the house, the title of the house, from both of their names only into the name of the well spouse, we completely avoid estate recovery of the state's lien on the house. So there is a lot that an elder law attorney can do to protect assets during your lifetime if you are a married couple and one of you requires expensive long-term care. But in order to implement these strategies, we need to have good estate planning documents. We need to have a good durable power of attorney with the necessary authority so that we could, for example, revoke a community property agreement, implement a separate property agreement, do any gifting that might be required. Though with a couple, it's rare that you need to do gifting. That's more for a single person. How can we do all of this? Well, we can't if we don't have a good durable power of attorney. That's why that is the most critical document you can have, not just to protect yourself and your voice, but your assets as well, so that all of your assets won't need to be spent down on the long-term care costs.